Attention Short Circuit listeners, you may have noticed we've been doing fewer episodes of late. That's because we've launched a new podcast series, Bound by Oath, on the 14th Amendment. You've probably seen it in the feed. I hope you'll give it a listen. In any case, I assure you we're not abandoning Short Circuit. We'll be back with much more judicial engagement in 2019.
The Institute
for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your aspirationally bi-weekly podcast on the Federal Courts of Appeals. I'm your host, John Ross, joined today by IJ Senior Vice President and Litigation Director, Dana Berliner, as well as Senior Attorney Bob McNamara. Dana, it's your first time on the show. Welcome. Thanks for being here.
Thank you.
Let's start things off in the Sixth Circuit. Bob?
You're not going to welcome me?
I am not.
Fair enough. So the Sixth Circuit brings us United States v. Veloso Alonso, and this case is spectacularly weird, and I'm crazy about it. So the United States brings a prosecution of Mr. Veloso Alonso for illegal entry, and he pleads guilty, and under the Bail Reform Act, the court can let him out on bail if the court finds that he's not a flight risk or a danger to the community somehow.
That's illegal entry into the country?
Yes, illegal entry into the country. He's an illegal immigrant. He's come back in several times. They're prosecuting him criminally for coming back in. And they also have a deportation order against him.
Had he ever committed a crime other than coming into the country? Do we know about that?
I am not sure. They seem mad that he keeps coming back in. It's not clear why he keeps coming back in.
He has a house here.
He keeps coming back in. He's had a lot of time to develop a life. But anyway, he pleads guilty to illegal reentry. It seems like he did illegally reenter. He got here somehow. And so the court's supposed to let him out on bail if it finds that he's not a flight risk. And there's no reason to suspect he's a flight risk because he has a house here. He clearly wants to be here. And the government responds, no, he's a flight risk because if you let him out on bail, we're going to deport him. And the district court says, what are you talking about? You brought this prosecution. If you want him prosecuted, you want me to use my jurisdiction. You can't whisk him away from me. Knock it off. And on appeal in the Sixth Circuit says, no, they're absolutely allowed to do that. The Bail Reform Act and the immigration laws just kind of say this when you read them in combination. The Bail Reform Act says you let them out unless they're a flight risk, but the immigration laws let people subject to a deportation order be whisked out of the country like this.
That went by kind of fast. Dana, did he just say that the government is saying if you let this guy out on bail, he will flee, and we know that because we're going to kick him out of the country?
So this is one of these many situations where two different government entities are competing against each other. The prosecutors want to prosecute and convict him, and the immigration people want to deport him as fast as possible, and they don't really care about him getting prosecuted, convicted, or sentenced. So if he weren't about to be deported, he would get out on bail because he's got a house here, he wants to live here. But the prosecutors don't want the judge to let him out because they know that if the judge lets the guy out, then the immigration people will deport him before his sentencing. So it's a fight between two executive agencies, which really they ought to settle somewhere not in court.
Which is kind of the district court's position. Like, you guys are both the executive branch. You figure out what the executive branch wants. If you want a prosecution, great, we'll do a prosecution. If you want to kick him out of the country, great, but don't show up in my courtroom with this guy you plan to abscond with. And I don't know, I think this is really interesting. It's kind of it shows the difference, I think, between law and equity in ways that are really interesting, because what the district court is doing is fundamentally equity. The district court is saying, look, you executive branch brought this prosecution, and you executive branch are not going to be allowed to say this guy's a flight risk because you plan to create circumstances that make him flee, whether you call it unclean hands or whatever doctrine you want to call it. You can't say he's a flight risk because you intend to force him to flee. That's not fair. And the Sixth Circuit is really just doing law rather than equity. They're saying, let's read the statutes, and the statutes say you can absolutely do this. That is what Congress has decided to allow.
Nonetheless, it seems like the executive branch, which should be speaking with one voice, is not speaking with one voice. It's speaking with several voices, and they're competing against one another in a way that doesn't make sense. The statutes, I guess, as Bob's saying, they can be read together to let the prosecutors prosecute and the deporters deport at the same time, but that's a thing that shouldn't need to be occurring. And they ought to be working it out. It's somewhat surprising, or it might be surprising to our listeners, that executive branch agencies compete against each other all the time and are constantly at cross purposes, and no overseeing body or person tries to sort that out. But they don't.
Yeah, I mean, I guess what the government would say is, look, our position is we're allowed to prosecute him, and he's just never allowed out on bail, no matter what the Bail Reform Act says, because if you let his feet hit the sidewalk, we're going to force him to flee. And there's a sense in which that is a unified position. We get to prosecute him, and he's just ineligible for bail. It's just a position that is, like, in light of sort of at least the intent of the Bail Reform Act, kind of bonkers.
Oh, you thought it was forcing him to flee. I think it's that they were going to just deport him.
No, that's what, like,
their claim was
when they say he's a flight risk, fleeing is us putting him on an airplane.
Right.
The flight risk is the flight we're going to put him on.
This does create a circuit split, though. So this probably at some point will have to go up, because the other circuits have been saying the executive branch has to choose either to deport or to finish the prosecution. And the Sixth Circuit says they do not have to choose.
I mean, it certainly seems like district courts are mad about this. And you can understand why. Like, the government comes in and invokes the jurisdiction of your court and says, by the way, if you follow the Bail Reform Act, I'm going to whisk this defendant away from you. And the district court says, no, you're not. I get to control my docket. I control who's in front of me. And I sympathize with the district court judges who are faced with this situation. Usually they get to control where the defendants go.
Is that a power? The Sixth Circuit doesn't consider whether the district court has sort of its power over its own docket to decide whether the person can be deported. I mean, the district court's basis for the decision was statutory, not just the inherent power to control its own docket. Does the Sixth Circuit opine on that? I don't think so.
No, it's why I say it's this weird division between law and equity, because it seems to me what's happening is the district court just thinks it has the equitable power to control this criminal prosecution and make sure it keeps its defendant until it adjudicates the case. And the Sixth Circuit just doesn't consider whether you have the inherent power to control the disposition of the defendant in front of you. And I don't know I don't know if that's actually correct as a matter of law, but it seems plausible to say that if the United States is invoking the jurisdiction of this court, that gives this court the power to tell the United States where the defendant goes and doesn't go for the duration of that case.
So what's the takeaway here? Is he's going to stay in jail now until he's prosecuted?
Well, so what happened here is the district court had ordered the federal government not to remove him from the country, and the Sixth Circuit has said, no, you absolutely can't do that. If you let him out on bail and they want to remove him from the country, immigration statutes allow them to do that, and you're just not allowed to make that order. So it's less, I think, about Mr. Velaz Alonso and more about how these cases are going to happen in the Sixth Circuit going forward, which I guess means no one who is subject to prosecution for reentry is subject to a deportation order is going to be eligible for bail ever again.
Well, there's a circuit split, so we may be hearing some more on this issue. But let's move on to the next case, Dana, which comes out of the Second Circuit.
So this is the case of John Gorman, a former corrections officer suing Rensselaer County and a bunch of people who work at Rensselaer County over what began as a domestic and family dispute. Mr. Gorman's sister had been dating another officer for 27 years, and then they broke up. And Mr. Gorman was in favor of the breakup. The other officer was not in favor of the breakup. There was a lot of arguing about this, and each officer was pretty mad at the other one as well as the sister. Things continued to escalate. And when the sister got a new boyfriend, her former boyfriend looked him up on the police system that allows you to see criminal records of other individuals. Found out that he had a criminal record and then began to talk about this to Mr. Gorman and the sister. Here's the thing. Police officers are not supposed to use the police information systems for their personal use and to deal with their private, personal vendettas that happen to be going on. Mr. Gorman, the brother, reported this to the authorities, who then sent him on to the state prosecutor because police really, really aren't supposed to be using these systems for personal use. After that, the entire police department retaliated against Mr. Gorman, causing him to take out the trash, accept deliveries, and generally making his life a living hell. He sued, and the district court found in his favor. And then the Second Circuit reversed and said, oh, well, sure, that guy should have probably known that he wasn't supposed to use this system for personal use, but he hadn't done it that much. He only did it once. And Mr. Gorman talking about the fact that his fellow officer had misused the system was not a matter of public concern because it had to do with this private fight. Now, this case shows a number of significant problems with the law. One is about the question of public concern. The general rule is that if a public employee speaks about something and it's a matter of public concern and they're punished, then that's a First Amendment violation. But if it's a matter of private concern, like I didn't get enough vacation this year, then they can be punished, and it's not a First Amendment violation. Here, we have a situation where it's definitely a matter of public concern. Police officers misusing their data systems is a matter of public concern, but it was also a matter of private concern because it related to this fight. And weirdly, the Second Circuit decides that it matters more that there was a personal dispute than that the police was misusing its police information system for private ends, which I find really disturbing. And even worse than that, it said because he hadn't done it multiple times, it wasn't an issue of public concern, which I think is even worse because everybody knows. I am quite certain the police know they are not supposed to do this even once, let alone multiple times.
So where does this public concern versus private concern, where does that come from? Where's the juxtaposition come from?
I mean, the basic idea is that the government, when it's acting as an employer, has to be able to act as an employer. There are all kinds of things the government can do to its employees that it can't do to ordinary private citizens. Like it can make its employees show up at 9 a.m. somewhere. The government can't make me show up at 9 a.m. somewhere, and we have to sort of allow for that distinction. But by the same token, just taking a government job doesn't strip you of all of your other constitutional rights. And so if you're engaged in First Amendment speech about a matter of public concern, that is your core First Amendment right that you haven't sacrificed, with certain exceptions, because there are always certain exceptions. But if you're strictly speaking about a matter of private concern, if you're just, getting into a fight in the lunchroom, then the government is acting more purely as employer. And so that's sort of the overall legal context in which this question is coming up. But what actually ends up resolving that question is not whether this is public concern or private concern, but just the broader shield of qualified immunity that says, a reasonable person might have thought it was either thing.
And what's, I think, particularly disturbing here is the issue of qualified immunity is one that is being hotly litigated right now in the courts, and that a lot of courts are becoming uncomfortable with. The idea is that government agents that do something wrong should not be punished if they wouldn't have known it was wrong. In principle, that doesn't sound totally crazy, but what has happened is that the case law has evolved that courts say people are immune for actions that anybody in their right mind would know is unconstitutional. And a lot of courts say that only if there is a case that actually says that, not just that it's unconstitutional, this action, but that a officer should know that it's unconstitutional, that is the only time where there's actual liability. Now, what's weird here is the Second Circuit keeps saying, we're not requiring a case. We understand there doesn't have to be a case. We're not requiring a case. And then they go on to hold that this officer might not know it was unconstitutional, which is insane. Because, as I said, there's no way on earth that every police officer in the entire country doesn't know they're not supposed to use the criminal records database for personal uses. I am sure they all know it.
And I think this really illustrates how the qualified immunity doctrine works in a very concrete way. I think a lot of people think the qualified immunity doctrine is a doctrine about when the police can punch you in the face, or at least I think people who listen to this podcast may think the qualified immunity doctrine is a doctrine about when the police can punch you in the face, but it's really a doctrine about complexity and the fact that the courts basically have discretion to decide how complexly they want to describe the issue before them. Because if you read Judge Droney's dissent in this case, Judge Droney basically frames the question as like, is reporting police abuse of power a question of public concern? And when you frame it that way, it obviously is. The Second Circuit has held that, courts all across the country have held that, and it's hard to think of something that's more obviously a matter of public concern than police abusing their power. And I think the Droney opinion is tremendously persuasive on that. And if you look at the majority seems to frame the question as, well, would you know it was a matter of public concern if he's talking about one-time police abuse, but he's also motivated by this long-standing family dispute? And you can always add more facts to the problem. Are you allowed to do this on this podcast? Well, Dana's never been on this podcast before, so she's never sat in that chair before when we answered this question. And it really boils down to just the initial decision of how you describe the constitutional question ends up answering the qualified immunity analysis.
But the constitutional question, I mean, that's absolutely right. And they're trying to add complexity to avoid liability for the police officer. But the constitutional question here really isn't that difficult. If you go back to what qualified immunity is supposed to be about, you shouldn't have to be liable if you couldn't have known that you were doing something wrong. This guy knew he was doing something wrong. And that's why I have... You're right, that's what happens with qualified immunity, but that's one of the reasons it's so frustrating, is that courts have gotten so far away from what is the actual animating principle behind the doctrine and have made it about layering doctrine upon doctrine and very specific facts, and really lost just the common sense approach of, in this case, did the person know it was wrong? Was the guy reporting something important? And is it cool should the police department have known not to make somebody's life a living hell for reporting a personal use of the system that everybody knows shouldn't be for personal use? And that's the common sense kind of just what's the bottom line here approach that courts seem to virtually never use in qualified immunity. And that's how we've gotten such a doctrine that now protects government agents when they really should not be protected.
Okay, and with that, we'll move on to the final case, which comes out of the Fourth Circuit. Bob.
Okay, swinging over to the Fourth Circuit, we have Mangum v. Hellenbeck. Hellenbeck, I'm not sure. And so what happened here is Mr. Mangum is convicted of a federal crime and has some pending state charges at the same time. And he goes and is sentenced for his state charges in Oklahoma. And the state judge in Oklahoma says, I'm going to sentence you for these charges, and I want your sentence to run concurrently with the federal sentence you just got. Spends some time in prison in Oklahoma, gets out, goes to federal prison, and he says to the Bureau of Prisons, hey, can you guys retroactively designate my Oklahoma prison as the place where I was serving my federal sentence, because these are supposed to be concurrent sentences, and I want to get credit off my federal sentence for the time I spent in state prison. And the Bureau of Prisons thinks about it, and actually they write to the federal judge who initially sentenced him, and they don't hear back to see what he wants to do, and they say, no. no, we're going to treat these as concurrent sentences, none of your state time.
Consecutive.
Sorry. Someday I will learn the difference between concurrent and consecutive, but today is not that day. Right. So the Bureau of Prisons says, no, we're going to treat these as consecutive sentences. Your state time doesn't count. And the case goes up to the Fourth Circuit, and the Fourth Circuit says, what are you doing? Like, circuit precedent says that a federal judge who is sentencing someone can't take into account a future state sentence that hasn't been handed down yet. He's not allowed to say whether it's consecutive or concurrent as to the state sentence that hasn't been imposed. Why did you even write to him? A sensible person, a reasonable person, would look at what the state judge did after both sentences were imposed. The state judge said consecutive. A reasonable person would treat these as concurrent. The state judge said concurrent. So, a reasonable person would look at the state judge and do that, and they send it back down.
There was actually a further wrinkle, because even at the time that that first decision was occurring, the law had changed. So when the federal judge sentenced, he was not allowed to comment on whether future sentences could be combined. But between that time and the time the thing went up on appeal, that changed.
Right. And so the case goes back down, and the Bureau of Prisons says, okay, we've got this decision from the Fourth Circuit. And they write to the original sentencing judge again, and they say, what do you want to do? And the original sentencing judge this time writes back and says, well, having looked at this case, I think what I probably would have wanted at the time was for these to be consecutive sentences. I don't want the state time to count. So the Bureau of Prisons says, okay, the state time doesn't count. We're going to consider our multi-factor test. And it goes back up to the Fourth Circuit, and the Fourth Circuit gives us a rare sighting of the mandate rule in the wild. And the mandate rule is very simple. It says that when an appellate court tells you to do something, you have to do that thing. And the Fourth Circuit says, look, we don't care that Fourth Circuit precedent changed about whether judges are allowed to consider the future state sentence. What we care about is what we told you to do last time. And what we told you to do last time was not care what the federal judge thought and pay a lot of attention to what the state judge thought. And you didn't do that. And so we're sending it back down for you to actually listen to us. And this, I think, shows a couple things. It's a good example of what happens when you defy the orders of an appellate court. But it also, I think, might be an illustration of how the Fourth Circuit works a little differently from other circuits. The Fourth Circuit expends what seems to be a lot of effort keeping cases with their original panel. Like if you have a case in the Fourth Circuit and you go up on appeal and it goes up on appeal the second time, the Fourth Circuit makes sure that the same judges hear that case to the extent possible. And I actually went back and looked at the original appeal in this case, and outside of Judge Davis, who was on the original panel and has since retired, they keep Judges Gregory and Harris on the panel. And so you see in the Fourth Circuit a lot of judges saying, wait, I remember this case. I remember what we told you to do. I remember what the arguments were. In a way that you don't see in other circuits. I mean, Dana and I had a case that went up to the Second Circuit 3 times, and all 3 times it was just a brand new panel. In the Fourth Circuit, it's much more common to go up and you get judges saying, well, last time you were here, you said X. And that might be, in part, what we're seeing with this sort of strict invocation of the mandate rule. That, like, it's not just that the Fourth Circuit told you to do this. We personally told you to do this. We remember this case. We remember what our reasoning was. And that's not what you guys did on remand, and we're pissed.
And what the government was saying was, well, since the law changed, we could just redo it under the new law, essentially. And typically there is actually a doctrine that when the law changes, you can, and your case is still ongoing, you can use it. So, for example, if we sue about a constitutional violation and at the time we sued, there was no Supreme Court case that said it was a constitutional violation, we lose. If we're up on appeal and there's a new Supreme Court case, we can say, hey, the Supreme Court announced that, in fact, this is a constitutional violation. Now we should win. But this is a little bit different because at the time that the judge sentenced and then gave away jurisdiction entirely, he was not allowed to comment on whether, at the time the federal judge sentenced, he was not allowed to comment on whether the sentences could be consecutive or concurrent. And since he didn't have the power at that time, the Fourth Circuit said you can't ask him what he would have done because he couldn't have done anything. And they went and asked him twice, which is they really, really wanted these sentences to be consecutive, and they were hoping they could get away with it. IJ actually had one case that involved what the mandate meant, and that was now more than 10 years ago. We were challenging, there was a guy who had a for sale sign in his window, and there was a constitutional challenge to that. It was decided on a motion for summary judgment. It went up en banc to the Sixth Circuit. We won, and it went back down, and the other side said, hey, they ruled just on summary judgment. Let's try again. We want discovery. We're going to relitigate the whole thing. And we had a huge fight about whether the case could then be reopened or whether the Sixth Circuit told them that they lost. And indeed, the Sixth Circuit told them they lost.
No, I mean, it's actually surprisingly common to go back down after an appeal and have your adversary try to do what the Bureau of Prisons basically did here. Is the Bureau of Prisons said, hey, we have this multi-factor test. We lost on appeal last time, so we start from zero with the multi-factor test. And, obviously the specific result last time was wrong. The Fourth Circuit said specifically that was wrong, but we're still starting from zero with the multi-factor test. And what the Fourth Circuit really says is, no, you don't take our answer, you have to take our opinion. Because our mandate said we're remanding for you to follow this opinion. And the opinion says, listen to the state court judge. And the Bureau of Prisons the second time around says, the state court judge's statement is dicta. It doesn't really matter. And it is, in a way, it's kind of refreshing to see something like that not work, to see a case go back up and have the appellate court actually stick entirely with what it said the first time and say, no, the way the system works is we tell you what the law is and then you do it. And that is not how it worked here.
Why didn't the circuit court just say his sentences are concurrent? Like, why even bother to send it back for them to reconsider it yet again under this opinion?
I mean, the Bureau of Prisons actually has to do the designation. He has served time in a state facility that's not a federal facility, and the Bureau of Prisons has to point to that facility and say that time counts as federal time. And so the Bureau of Prisons does have to do the thing, and I don't think the Fourth Circuit thought they were remanding for sort of the case to be reasoned afresh on a clean slate. That's just how the Bureau of Prisons treated it. I think reading the opinion, the Fourth Circuit clearly thought that's what they did last time. They sent it down with instructions to treat these sentences as concurrent. And they ended up getting the case back a few years later with the sentences still being treated as consecutive. But it's federal appellate courts, I don't think, feel like they have to micromanage. They lay out what the law is. In this situation, the state judge's statement about concurrent sentences should be entitled to a lot of weight. And then they just remand for other people to follow that mandate. They don't say on remand, you are going to fill out this form and then you are going to stamp that form. The expectation is that people will follow their orders. And when people do not follow their orders, sometimes people cannot follow their orders, and that turns out to be okay. And today was not that day for the Bureau of Prisons.
Okay, that concludes the show. Thanks for listening. We appreciate you. Until next time, this is John Ross decreeing that you should get engaged.